Okay, let's see here. Okay, is it starting? Okay, now how am I know what I'm doing? What I'm doing? Okay, I guess I'm live. How can I tell? I'm sorry, I'm doing this from my hold up. Okay. I guess I'm live and I'll give it a few minutes to see if I don't know how to tell if anybody's watching or not. Um okay, let's see. Gotta guess gotta wait it out. Um I don't see. Well, let me go ahead and get started because I don't want this thing to kind of linger out. I really would like people to interact if they had any questions. So that's why I'm trying to wait. I'm not, let me look at this other thing here. I finally was able to get the space before they close. It's after 4:30, so they allowed me to take my mask off and be able to produce this quick video. So, excuse me, for the people come in and start to sanitize and doing everything they got to do. So I want to check something real quick because I want to see if I'm actually. How can I tell? I can't tell if I am or not, if I'm live or not. It says here live, but I can't tell. And I'm looking at my phone, but I don't see. I don't see. I'm hoping I'm doing this right. I can't tell. I can't tell. It's not on here. I don't see it on here. And oh, okay. I see it here. I am live because I see it on my page. Okay, but nonetheless, I'm gonna go ahead and get started, and hopefully people can catch up to what's going on when they see this. So, Jimmy, so I want to this video is dealing with anybody that's a renter, gig worker, independent contractor, sole proprietor. If you do any kind of contractional work, there's something you need to know. Just a little history. I just had a hearing today, and this is why I'm going live because I don't want anyone to end up in a situation that I ended up in. Sometime, being honest and fair, comes with, even though it comes with a lot of advantages, it seemed like a disadvantage when when people take advantage of it. So, nonetheless, the first part of this is the rental side for rentals. Excuse me. In the latter part is for independent contractors, gig workers, etc. And this is what happened. I used to reside in Wellington Gate Apartments. It's a Henderson-Webb incorporated apartment complex in Parkville. And I resided there from 1998 to 2006. I got injured on the job, and from the injury, I couldn't walk. I was all messed up. So I let the management know, hey, I'm not going to go into a new lease because I don't know when I'm going to have any income coming in. I can't work, can't do anything. I'm not getting disability or anything like that. So instead of me letting the debt build up, I decided to remove myself out of the property, and try to get myself together and, stuff like that. So nonetheless, to get this information, I move out of the property. I never receive anything from them saying I owe them any money, you owe rent, you owe anything. So I'm thinking all is well. Well, in 2010, I posted that, hey, I'm getting ready to move. I'm all excited because I'm finally able to get myself back up after all of these 4 years. And so I'm excited. I posted, and the property manager there, Rodney Faison, called me and said, no, he inboxed me on Facebook, and it's the property manager for Henderson-Webb. So he inboxed me and was like, what's up, what's going on, whatever. Then he contacted me again, and what I end up finding out, not finding out, but the guard ended up revealing. Now, well, let me say this too, because I want to make sure people understand I am not a lawyer. I have never been to law school. I have never sought to be an attorney or in the legal field at all. Everything that I'm telling you that I found out everything that I'm telling you of all of the things that need to be done to protect yourselves as a renter, independent contractor, get workers, sole proprietor, etc. All this is coming from the Lord. The Lord gave me all these revelations, all of these things. But unfortunately, the law is prohibiting those benefits from the Lord. But nonetheless, the benefits come on the other end. But let me say this. So what happened is I had I'm echoing here. Let me turn this off. So I'm sorry, turn this off. Okay, so what happens is the Lord showed me there's a correlation between every time this property manager calls me, contacts me on Facebook Messenger, and me getting hit with something from this management company. So after this happens, a year later, now mind you, this is somebody that I wasn't dealing with way back in the day because we used to work together, CES Security, and he made an allegation that he slept with me, and I blasted him out in front of everybody on the job. So I didn't have no dealing with him. So years later, in 1998, about 2 decades later, I'm working at this place. And about a decade later, I think. But anyway, I'm working at, I applied at this place for an apartment, and there he is. He's there. So, of course, I don't forgive. I don't went on. We grown, paid no mind to it. So, of course, here and there, he'll make little comments, little sly, little slick, little advanced marks and stuff. I don't pay no mind to it. I laugh. I'm like, it's no big deal. However, so when I leave, like I said, I get injured, can't walk, this and that. I leave the property, they let them know. I never received anything from them, saying anything old, no damages, no nothing. And I'm thinking, well, it was a week into the new thing that they allowed me to move on the 8th. So they're probably going to keep the security deposit. So I think no more of it for the 8 days. So here it is, 2011 come in, and next thing I know, I get this notice to go to court for back rent. So I'm like, what is this? So it's Henderson-Webb. So for their wanting to get apartments. So I go there, go to the court, and mind you, they said they gave me the notice at my mother's address when I lived in Clark's Lane. That's where I actually got it from. So there was 2 different addresses. So keep that in mind. So anyway, what happens is I go to court. And you go into the court. Then the judge said, "Well, y'all want to talk outside?" Of course, the attorney for the Henderson-Webb said, "Yes." So we go out. What is little? And we're talking. So they're saying, "Well, you owe rent for December, January, and February." I said, "Well, no, sir. There's no way I owe that." So I pull out my receipts. So they go to receipt for December and I go to receipt for January. But I wasn't sure if January actually got paid, though I had the money order, because I know that I was moving and I didn't have any income coming in. So I don't know, even if I knew at that time you can even cash in money orders that you have purchased. So nonetheless, I didn't want to say that I paid something that I didn't. I said, well, maybe I didn't, so I'm thinking, well, maybe I used that money to move, maybe I cashed it in. So I didn't want to say that I paid something that I did. I definitely knew December was paid. So what happens is, I had previously called the I had previously called the where I got the money order from. And one thing, I noticed is that if you get a money order, a lot of times you can only trace them up to 2 years outside of a bank and maybe up to 3 years from a bank. So if you ever get a money order, just know that if you do not validate who cashed it within that certain period of time frame, you're not going to be able to find out. And so since I couldn't find that out, I didn't want to say I paid something that I didn't. So I went on, took the hit. So the guy said, okay, well, we'll take that December off, and then we'll add our attorney fees in, and then that'll cover that. So when they got the judgment for $15.99, part of that was attorney fees. And again, I'm thinking, okay, well, I must owe it. They said it. I'm thinking that they can take me to court. But one thing that you might not know is they cannot take you to, on a contract. Every state has a contract law, which means that you can only collect any debt that's owed within a certain period of time. Here in Maryland, is 3 years. And what they did is they went into court. They was trying to say that because their lease is a specialty, and they had a clause, they had a seal where you signed your name, the word seal, and then a clause where it said this is a specialty lease, allowed them to take the 3 years and extend it to 12, which is illegal. It is illegal. So if you are on a lease right now in Maryland, and your lease anywhere, mainly a Henderson-Webb lease, or properties that's managed, so-called by Henderson-Webb, but they actually own it. You want to look on your lease. If you sign it where it says seal, and or if the clause, like the second or third clause, somewhere in there it says that this is a specialty which they can extend for 3 years or 12 years, it is illegal. They cannot. If you are a tenant of any management company here in Maryland, and or you were a tenant, and first of all, when you move out, you're supposed to receive a walkthrough, and within 45 days, you're supposed to receive a statement saying, hey, this is the damages, this is the money you owe us. We're going to do this with your security deposit. If you get anything back, this is what we're going to send you. If not, this is why, and whatever you owe us, this is what you got to pay us. If they don't do that within 45 days, 45 days by law, they cannot get any of that money. They can't get anything from you if you owe it, if they did not submit that to you. Also, after 3 years, they cannot come after you for that money. One thing I will say, if you're the kind of person like myself, honest, and you say, well, I might have owed something, maybe it was something I still owed, or you know for a fact that you owe something, then what you do is when you go to court, if they take you to court, again, it has to be within 3 years of the last day that you were in that property when the contract ended. And one thing you do not want to do, I don't care if they say you owe us $5,000 and we can settle this right now for $3,000, and you agree to it and you go into court, and then they tell the judge, do not do that. And the reason why I say never consent to any judge, do not do a consent judgment, because what happened in my case is that because it's a consent judgment, you cannot go forward in court and say, hey, this is fraud. Here go evidence of the fraud. There's nothing they will do with it, because of the way this judge Panos, Panos, and the circuit court said that you can't do nothing with it. Now, if I did not consent, then they would review it and take a look at it. But because I consented, I only had 30 days to consent. But back then, who knows? I didn't know that I was being taken advantage of. I didn't know that they was getting over. I didn't know that they conjured up a bill that I didn't know, and that they was taking me in. I didn't know none of this. So this is again to say, if you are a renter, do not ever consent to a judgment. Go into the court and have your say. Let them have their say, and let the judge make his ruling. Pray to God that he will deal with it and be that, because if you have a consent judgment and you find out later that that judgment was illegal, there's nothing at all you can do about it if it ain't in the first 30 days. So that's the first part. So after this all happens, now, this was in 2011. So in 2020, what, 2021? No, 2020. I'm saying 2020. Right when COVID had hit, I applied for an apartment again with Henderson-Webb. Now, mind you, I'm thinking that the judgment that they got against me, the consent that I did, all this is legal. I'm thinking all this is legal, is fair, is widowed, etc. So anyway, apply for the apartment, get the apartment. They changed the amount of the apartment twice. So 3 times I went in and they changed it once, then they changed it again. So 3 times the amount of the apartment was changed, and then they went from saying you need 1 month security deposit to 2. So, and I'm like, okay, but I already know that I'm blackballed here in Maryland because of the advocacy work I do dealing with tenants, advocacy work, and the law that passed with my name on it, or the case that passed my name on it, set a precedence of a law that don't allow landlords to take tenants in the rent court anymore for just anything. They can't say, well, I put in that bub, it's $30, and you say, well, it may be $30, but it's only worth $5. They used to can take you to court and try to evict you for not paying that money. They can't do that now. So my name is synonymous with landlords as well as the court. So I knew that they were, at this point, I'm realizing they must be trying to keep me out. They don't want to, have to deal with me because of this hurts them, and I guess they feel it hurts them because they can't get over on tenants like they used to. So then after that, they said, oh, by the way, because when I said, okay, because I said, I'm going to see what they're going to do. So I said, okay, I have it. I'll pay it, no problem. So I'm like waiting, and then next thing I know, they said, oh, well, by the way, you have a debt with us. I said, okay, no problem. Send me a letter stating that this is written off. And then we go from there. I pay it, do what I got to do, because again, I'm not thinking and knowing that this judgment was illegal. So what happens is I turn around and I ended up not moving in because they wouldn't give me things saying that it wasn't written off. I'm like, you're not gonna get written off and get credit for it to turn around and get money out of me again. We're not gonna do that. We're gonna play them kind of games. So the height of COVID, and it was October of 2020. Henderson-Webb Incorporated used RUPP and Associates to file against me for a right of garnishment of property other than wages. They sent it to Lyft because, of course, they know where I'm employed because of my application. So Lyft, in turn, implements a wage garnishment. So I'm like, wait a minute, hold on. First of all, I'm not even understanding what's really happening because I'm like, nobody told I didn't get a letter. I found out from Lyft when I found out Lyft was stealing from me, and I accused them, and like, here's the evidence. You steal from me. What is this going on? And then all next thing I know, you got a wage garnishment against you. So as I'm digging, I'm finding, well, for the right of garnishment of property is not a wage garnishment, and you can't switch out the two. So to shorten this story, because it could be very long on this case thing today, I have a hearing today, and the judge is saying that they just believe it's just the wording that they messed up on. They should have just said garnishment, but they honored it. So that means I had worked a total of 48 weeks straight, without a penny coming, not one penny coming to me. And the courts denied every motion over and over that I'm putting in, like, hey, this is illegal, this is what's going on. They did this, they did that, and so it's just all these other different things. So today they allowed it to still stand. So the defendants, Rupert and Associates, the attorney David Carlin, he says, okay, he asked the judge, do we want to talk before? Do we want to talk and this and that? And I'm like, no, definitely, because I know I'm not going to sit into a thing. So before it was over, attorney Carlin asked me again, or recommended again, that we just, can we get offline? They can put us in another little, I guess, Zoom room, and we can talk and make some kind of something between myself, Henderson-Webb, and them about this $1,300 balance. So, because with the interest and stuff, it went from $1,500 to almost 20 or 25, 2,600, whatever it was. So, and it's clear that this guy is a little frantic because he called Friday and he left a message, but he didn't tell me to call me. He just said, Felicia Lockett, it's David Carlin. Here's my number. I can be reached at. So to me, you didn't ask me to call. I'm not calling. But today again, you can see going like this, and he going through, because you can tell he already know that what him and Henderson-Webb did is illegal. And I'm gonna give you this other tidbit. Henderson-Webb been sued multiple times over and over again for the same issue. There was a case in let me get it right. There was a case in 1998 filed and got resolved in 1999, and it's basically almost a mirror image of my case. And this case was let me get it real quick. Because I want y'all to have this stuff. Like I said, it's stuff that you definitely want to have, because where is it at? Because you want to be able to quote. If you're in the situation now, you can use this to help yourself out. Yes, Spencer versus Henderson-Webb, 81F sub SUPP 2D582. It was in the circuit. I think it was in the Court of Special Appeals. But anyway, if all you gotta do is type in Spencer versus Henderson-Webb in Maryland, and it'll come up. And it was the same situation where they tried to extend that 3-year to 12-year. So, but the judge like, no, this ain't gonna work. And in 2019. The Special Court of Appeals put a stamp on it and says that no, even if the only way you can extend for 3 years, 12 years, if it's a non-residential contract. The residential contract cannot be extended. So just to know that. And so again, know that if you are a rideshare worker, independent contractor, sole proprietor, if a creditor, I should have said not debtor, but if a creditor hit your account, figure, okay, this is where this person is getting their money from, whether it's a bank account, whether, just say if you got a contract with the state, whether you got a contract with this hotel or whatever it is, if they find and they attach it, everything that you make in, they get 100%, 100% of it, 100%. So I just wanted, like I said, warn you guys right now. I'm going to be moving and speaking with some other. Okay, sorry, I'm almost done. Speaking with some other civil rights people as well as some lawmakers in order to get these laws changed, because there's no way that if fraud is found, that nothing happens to the other party. And one thing I've learned about this tenant landlord laws, the landlord is protected to such a degree it don't make any sense. However, they don't win all the time, because I won several cases against high-powered attorneys. And I know one in particular, this Diane C. Briscoe, downtown, get $310 an hour. And again, I'm not a lawyer, never studied to be one, never desired to be one, but because of God was instructing me and guiding me, I was able to win these cases, even against this high-powered $310, very, what's the right word I want to use for her? What's the right word I want to use? I can't figure out the word I want to use. But yeah, but I won against her. And it's clear that she makes up her own guidelines dealing with this stuff, which is provable. And I don't say anything that I can't prove. So again, I just want y'all to know, if you are a renter, be aware of the laws. If you are a gig worker, rideshare worker, independent contractor, sole proprietor, be aware of these laws. And like I said, never consent to any judgment you owe. If you go to court, don't settle it outside that court. I don't care if it look like you may save $1,000, $2,000, $3,000, whatever dollars. Do not do it. Mainly if you don't, unless you know for sure what they are doing to you is 100% legal. If you don't know, then do not consent, because once you consent, if you don't figure it out within 30 days, you have no recourse. You are stuck with whatever that judgment is. The second part again is, as far as the garnishment, that's another issue in itself. That if right now in Maryland, if your creditors say you owe this money, they can give a right of garnishment, mainly if you are in that category, 100% of your income. Mine was taken for 48 weeks straight, during the height of COVID, 48 weeks straight. So again, if you are a renter, know the law. If you move out of a place, if you all have a residential lease and you move out of a place, the landlord is required to give you within 45 days your supposed to give you a walkthrough, as well a walkthrough within 5 days of you moving out, and within 45 days they're supposed to give you a notice of any damages, anything what they're going to do with security deposit. And if they don't, you can actually take them to court and get 3 times your security deposit. Also, at the end of your contract, when you leave a rental unit, when that contract ends, if you owe anything, they have 3 years to collect. If they have something on their lease that says seal, where you sign your name, or something in that lease that say this is a specialty lease, it's illegal. In Maryland, and other states may be the same, but definitely in Maryland, they cannot stretch a 3 statute of limitation of collections to 12 years. Henderson-Webb Incorporated is famous for this. If you research them, you'll see case after case after case after case that this has happened. Also, if you are, like I said, a sole proprietor, a renter, or anything else like that, you want to make sure that you're very clear of making sure that you don't have any illegal debts against you, because if you do, they can come and take 100% of all your wages for as long as you get them until that debt is paid, even if it's illegal debt that you didn't know from before. So just wanted to make that clear. I'm going to make that known. If anybody have any questions, put them in the thing and I'll be more than happy to answer it. All right, bye. Okay, how you turn this thing off? All right.